103, that is murder. There are two things to me. The actor's race in this situation was, your lordship, that they pinned him down because they were aware if we leave him free, he will be a problem for us because we have called for ransom. The second thing was, your lordship, the conspiracy. If you intended to go to a Durga temple, you should have gone to the Durga temple. You planned a plan A, you did not take care of the plan, and you again went to a place else. That means you had an inherent bad intention about the scene. The third thing is kidnapping for ransom. There stands accepted even from the side of the defense that there was a call for ransom, and they did not object that who was the person calling for ransom. Thus, also accept the fact that their own accused were the people who have called for ransom. The third thing is organized crime. The interpretation of organized crime is, your lordship, any kidnapping that is done for ransom or murder can be both of them took place. Thus, proving the point of section 111 stands true. Except for theft for vehicle, as I've objected then and there, as it was not an informed consent from the side of the owner's, the vehicle's owner, as he was the person who was riding, Raju was not a legal owner of the vehicle. That person is, or who is the person? Forehead, there are boils on the back, and there are multiple rib injuries and the chest injuries. That justifies the point that there were voluntary hurts caused to the victim. Your lordship, the concluding point is, the deceased in this situation had a promising future. He was mere 21 years old, who had a financial backing to make sure he achieved the stars. Yet, the greedy people killed a promising career just to make sure that they live a lavish life. Having everything from bad character to antecedents to mens rea to actus reus, they should not be set free. People who are in college and are getting education are doing such crimes shouldn't be the part of the society, and definitely shouldn't be given a leniency in the statement because they took a life of someone who definitely would have been an asset to the country. Now the honorable courts, the prosecution would like to play their own side. That is to first sentence all the accused to the maximum sentencing under all the following charges, except theft for vehicle should be charged specifically towards Raju, as he was the one on record stated, I bought the car. I was the one who was driving the car, thus proving this point. Except for that, all the other things should be charged in its maximum, and if the victim compensation scheme shall by liberal interpretation be applied on the same case, should the parents be given some compensation for losing their own old stick in the old times. The counsel for the prosecution will be highly to it from the side of the prosecution. Much obliged, your lordship. We would like to conclude if there are no points of rebuttal from our side after the closing statement of the defense. Much obliged, your lordship.
Your Honours, counsel seeks permission to present the closing arguments. Your Honours, as accepted in the very first part of the trial by prosecution themselves, that Your Honours, as accepted by prosecution in the very first part of the trial itself, that there is no direct evidence present in the instant case. The whole case is relied upon circumstantial evidences. And Your Honours, for that I am very thankful, in fact, for my learned prosecution, that they provided you with the case law, which mentions the very important factors when circumstantial evidences can be relied upon. Your Honours, if I may please again remind this Honourable Court that they should exclude every possible hypothesis except the one is to be proved. And Your Honours, in all human possibilities, the charges or the accusation should point out to accused and accused only, Your Honours. In this case, we humbly submit to this Honourable Court that prosecution has completely failed to establish a proper chain of evidences which will point the guilt towards accused, Your Honours. Your Honours, if we deal with this section by section, which are sections charged on my clients. Your Honours, the very first and grave section which is charged is section 103 of murder. Now, Your Honours, they talked about mens rea and actus rea. They completely failed to establish any mens rea or even motive from the side of accused, Your Honours. On mayor being poor, Your Honor, it is not to be accepted that poor people will ultimately kill the rich person who are with them. This cannot be a ground of mens rea for the murder, Your Honor. There must be some planning, plotting, even the motive we have to establish, Your Honor. Just because my clients are poor, it cannot constitute as a mens rea to kill someone who is rich, Your Honor. Further, if we talk about the actus rea, Your Honor, the high reliance of prosecution were on the last seen theory. Your Honour's, last seen theory can be relied only when the time lag between the time deceased was seen last with the accused and the time of the murder is narrow. This time lag must be narrow to rely on the last seen theory. Now in instant case, Your Honours, the post-mortem report which is submitted does not mention the time of death of the deceased, Your Honours. Also, the investigation officer, while in his cross-examination, was highly confused about at what exact time the deceased was dead. Your Honor, deceased was last seen with accused at 21st of October. His body was recovered at 24th October. This time lag between the last seen with the accused cannot be relied upon, Your Honors. Further, Your Honors, the post-mortem reports does mentions the very grievous hurt signs on the body of deceased, Your Honors. And we are very sorry that Suhas had to face all this. But those marks, those injuries, those hurting injuries are nowhere linked with the accused, Your Honors. How the prosecution has failed to prove that those injuries were caused by the hurt by accused, hurt by my five clients, Your Honors. Your Honors, the death was caused by strangling from the nylon rope. Your Honors, prosecution failed to establish that the strangling, that the nylon rope was in possession of any of accused at the time of death. As Your Honors, there is no direct eyewitness or nor even a forensic evidences which proves that this nylon rope strangling was done by my clients, Your Honors. And again, for the murder or even for the kidnapping and abduction, they have relied upon the testimony of service boy in instant case, Your Honors. Service boy in the last statement of, and they have not recalled the service boy again, Your Honors, in last statement of closing argument, he himself stated that the incidents which he saw was so casual in nature that he forget about it after 5 to 10 minutes, Your Honors. This casual incidents cannot be compared with the grievous charges of murder, Your Honors. To prove kidnapping, Your Honors, there must be a very important element, and that element is element of force, Your Honors. In instant case, Suhas voluntarily agreed to go on this trip, Your Honors. In the whole chain of events which happened in instant case, there is no mention or no proving by prosecution side that Suhas anywhere retaliate about his presence with the group, Your Honors. He was voluntarily present with for the whole time, Your Honors. So the abduction or kidnapping cannot be charged against my clients, Your Honors. The ransom call, which was allegedly made by my clients, Your Honors. The call records of the father who received the ransom call or the call records of the BSNL cards which was in possession of accused are nowhere submitted to this honorable court. So the prosecution has failed to conclusively prove that the ransom call which was received by father of deceased was made by my accused, Your Honors. And Your Honors, the ransom money which was transferred by father of deceased was transferred to an account which is named as Miss Vibha. Now Your Honors, prosecution has completely failed to establish the link between the person Miss Vibha who received the 15 lakh of ransom with the 5 accused who are charged in instant case, Your Honors. So neither they have established that the call of ransom was made by accused, neither they have established that the money for ransom is deposited in the accounts of accused. Any of the accused, Your Honors.
Your Lordship, there stands two major objections. While closing arguments, you cannot add anything except for what you have already stated. Nor the prosecution nor the defense ever in the entirety talked about Miss Viva, nor the defense ever in the entire arguments talked about post-mortem report. Now, using the post-mortem report to justify their closing argument is not allowed. It is barred by law because closing statement has to be the summing. Your Lordship.
Your Honors, in meantime, if may I... Your Honors, because there is restriction on taking witnesses for the time being, they have only took 3 witnesses. But Your Honours, we have the statement of IO, we took the statement of IO. Your Honours, the post-mortem report is submitted to the Honourable Court and the defence side. So we have every right to argue about the post-mortem report, even if the chief of post-mortem is not presented in the witness. Much obliged, Your Honours. Your Honours, about section of organized crime. Your Honours, for the sake of arguments, for an instance, we even consider that the organized, that all these 5 people were organizedly done this ransom thing. Your Honours, still, it is an isolated act, Your Honour. For organized crime, there must be a syndicate who is constantly working about any financial crime. Your Honours, prosecution has failed to establish this thing that all 5 accused or any accused was part of any syndicate who is doing constantly or repeatedly and financial crime. Therefore, section 111 of organized crime cannot be charged against my clients. Your Honours, about section 126 plus section 115, which is wrongful restraint and voluntarily hurt. Again, Your Honours, the only reliance about these sections are placed on the testimony of service boy, Your Honours. There is no evidences presented to prove that there was wrongful restraint, Your Honour. Suhas was never restrained by any of accused. He always was voluntarily involved and he always did everything voluntarily. Hurt, whereas Your Honours, there must be an support, hurt must be supported by any medical evidence or any eyewitness testimony. Now, as we all have come to conclusion, there is no eyewitness testimony and the medical report is nothing but funny, Your Honours, as there is no fingerprint examination, there is no DNA examination conducted in this whole matter, Your Honours. Therefore, the injuries or the hurt caused to deceased nowhere is linked with accused, Your Honours. And the last 3 sections, which is section 303, 305 and 61. Your Honours, 303 and 305 is theft and theft in vehicle, Your Honours. Whereas theft is only charged for the credit cards. Now, Your Honours, this credit card as alleged by the prosecution are of ownership of Harshad Mehta and Zafar Ali, Your Honours. The statement of these 2 people are not on record, Your Honours. Your Honour, freezing of credit card is so easy. If the credit cards are stolen by accused from these 2 people, they would have called the bank and freezed the credit card within 1 hour, Your Honours. Credit card is freezed. Accused used this stolen credit card for 4 days, Your Honours, and there is no report of any stolen credit card or even stolen car, Your Honours. Therefore, the charges of theft and theft of vehicle cannot be placed against my clients, Your Honours. Therefore, it is most humbly submitted before this honourable court, Your Honours, that prosecution has failed to prove guilt beyond any reasonable doubt, and defence submits that evidence presented by prosecution is riddled with contradictions, gaps and absolute procedural lapses, Your Honours. None of the evidence conclusively established the guilt of accused either individually or collectively. And for this, Your Honours, in light of all the issues raised, argument advanced, we pray to this honourable court to please acquit Raju Munir, Manu Singh, Dilip Sutar, Shantanu Murthy and Prakash Hegde under all charged section of Bharatiya Nyaya Samhita. Pass any other order which this court deems to be fit in justice, equity and good conscience, and all of this is humbly prayed to this honourable court. Much obliged, Your Honours.
Your Lordships, there stands Your Lordship, there stands one interpretation of relevancy of facts. As I would like to apologize and plead ignorance of the grounds, it is not barred by law, but it is settled norm that while giving closing arguments, you cannot add anything. Apologies to both the sides, to the Honourable Bench and to the defence. Except for that, I would ask the Honourable Courts to please grant us rebuttal, as there are some specifications added up. Much obliged, Your Lordships. Indeed, Your Lordships. First, Your Lordship, the problem was that they have said that the chain of evidences or the chain of the entire scene was not proved. We proved from the initial point that Subhash went by consent. But when he went to the second hotel, he revoked the consent when he was pinned down. as corroborated by the statement of the service boy. The second thing was, it was with the service boy when Subhas was last seen. And if you are a good friend, as Raju stated, he was our good friend, you should have directly went to the father first to prove that we cannot find him. As the last statement given by Raju was, we were going to tell him that his son was missing. And the previous statement was, we thought he went home, thus proving the contradiction and proving also the point that he himself is not confident he was it, that he went by consent or he was missing. The second thing, your lordship, the point of murder, the actus reus, mens rea of both stands proof. The actus reus in this situation was, they made sure the entirety of him to be in the car, going to the hotel, being pinned down, being strangulated is what is actus reus. The mens rea was, they already called his father for ransom. If he would have been set free, the concluding points except for that would be, some of the points as forensic takes time, your lordship, it is still under investigation and would be submitted to the honorable courts within time. The circumstantial evidence is supported by the Sharada judgment, as it said it had, I have categorically proved first murder, then organized crime, thus proving everything aligning to the circumstantial evidence. Except for that, the person who will make offer to pay amount and ransom, as it was not stated by any of the people, nor the side of the defense, nor by us, that what was the account that it went to, and it was not even objected or rebutted from the side of the defense. They accepted the fact that it went to somewhere around their own people, nor they did accept that you called his father or not. Not Raju on record stated that we did not call his father, but on the other hand he said we called his father. That means it can be construed that he called his father for ransom, and it was not rebutted. And by concluding, your lordships, much obliged.
Your Honor, if I may take 30 seconds, then sorry. Your Honor, they are misleading the court. They said that Raju accepted that he went missing and then said that he was voluntarily gone. Your Honor, Raju firstly said that he voluntarily gone at night. When they couldn't find him, then they thought that he was. Further, we did objected on the point that the money was transferred to Ms. Vibha and not to any of accused, and she is not guilty. Your Honor, all the facts which in rebuttal they stated are not be submitted, Your Honor. It might not be taken on record. Obliged.
हो गया खत्म?
नहीं अभी तो रिजल्ट्स आएंगे
उसके बाद खत्म।
ठीक है इधर क्या शो हो रहा है क्या हो रहा है
जवाब दिया जाना चाहिए, ठीक है, ये तो एक चीज़ है।